we were doing consideration chapter in business law. We have already discussed in the first part what is meant by consideration. In this video we are going to discuss the valid essentials of a valid consideration, right? So we'll discuss the points first, and one by one we go into the detail of each point. You should be clear by now that there are two parties for a contract, at least two parties. A who's making an offer to B and B is giving the acceptance, right? So A is the promisor, B is the promisee, or A is the offerer and B is the offeree. So first point is that consideration must move at the desire of promisor. Promisor की desire होनी चाहिए, right? So the consideration is moving at the desire of promisor. It is not that you are doing something on your own. In this you have to study the case of Durga Prasad versus Baldev. Second, the consideration may move from the promisee to promisor or any other person. In this we have to study the landmark case of Chinaya versus Ramaya. Then consideration may not be contemporaneous with the contract, which means it may not move simultaneously. It can be past, present or future. We will study this in detail. Next is consideration must be something of value or having worth in the eyes of law. In this we have two cases, Collins versus Godfrey and Ramchandra Chintaman versus Kalu Raju. Last point is consideration need not be adequate. In this you need to remember two theories, that is the peppercorn theory and doctrine of fair exchange. Let us now study all these one by one. First point is consideration must move at the desire of promisor. So if A is offering something, B is doing that on the desire of A, not himself or herself, right? So it should not be voluntary. It should be an act or abstinence at the desire of promisor. So promisor may or may not be the beneficiary, but it was the desire of the promisor. Let us see the case. There is a famous case of Durga Prasad versus Baldev, in which Durga Prasad built a marketplace to impress the collector, right? Now the shopkeepers of that market agreed that they will pay some commission on the sales to Durga Prasad. Baldev occupied one of the shop in that market and he refused to pay the commission, right? Now Durga Prasad sued Baldev that all the shopkeepers have to pay a commission because I have developed this marketplace. Now the question was whether Baldev was under legal obligation to pay him or not. The answer is no. Why? Because we have to see who was the promisor and who was the promisee. Was it the shopkeepers that told Durga Prasad to build the marketplace in the first place? Did Baldev paid? Was it the desire of Baldev that he should develop the marketplace? The answer is no. Durga Prasad had built the marketplace himself, not at the desire of Baldev. Hence, Baldev is not obliged to pay him, right? So this states that whatever you are doing at the desire of promisor, and Baldev here is not the promisor, right? Hence, he is not obliged to pay anything to Durga Prasad. Second point, consideration may move from the promisee to promisor or any other person, right? So B is giving to A or B is giving to any third person on the desire of A, right? So beneficiary कौन है? Promisor भी beneficiary हो सकता है या promisor बोल सकता है कि आप third party को दीजिए the consideration which I have to receive. So we will study this in detail in the next video. Privity of consideration is not essential for privity of contract. right? Privity of contract means that you should be a party to the contract, but you may not be a party to consideration. Let us see the famous case of Chinaya versus Ramaya, in which a lady passed on property to her daughter Ramaya, and there was a condition that Ramaya will keep on paying Chinaya a monthly sum which was earlier paid by A, right? So A was paying a, a fixed amount, which is annuity. Fixed amount is also known as annuity. So she was paying some amount to Chinaya, and because the property was transferred to Ramaya, she asked her daughter that now on my behalf you will keep on paying Chinaya. Ramaya agreed to pay the annuity. Later, she denied that she will not pay anything to Chinaya, and she raised a question that for a contract to be there, there should be consideration for both the parties. If she is paying the annuity, what is Chinaya paying to her? Nothing. Hence, she said that I am not going to pay you. Chinaya sued Ramaya that he was not party to the consideration, but he was party to the contract which was signed between her mother and her, and she agreed to the condition that she will keep on paying the annuity. Here Chinaya won the case. Why? Because he was party to the contract, although he was not paying anything, but the benefit of this transaction was to be passed to Chinaya as per the instructions of the promisor here, that is A, right? So A told that the benefit would be going to Chinaya. Hence Ramaya was supposed to pay Chinaya. I hope the case is clear. Let's move to the third point. Consideration may not be contemporaneous with the contract, which means consideration could be past, present, or future. So past consideration means that something is done before the date of agreement at the desire of promisor. For example, A has taught B for a month, and now at the end of the month B is promising to pay for the services which is already rendered by A. So you are paying something for which the act has already been done in the past. Second consideration is present, which means it is moving simultaneously with the promise. For example, easiest example is cash sales. So you are buying something and you are paying on the spot for the product or services you are receiving. Third is consideration is promise to be performed in future. For example, A promises B to sell the crops which will be harvested next season, right? So we are promising now, but that promise will be fulfilled in future. When you have the harvest, then only you can sell to A. So this is example of a future consideration. Next, consideration must be something of value or worth in the eyes of law. So law should recognize that whatever consideration you are promising is valuable. It should be real, it should be competent, and it should not be what physically impossible. For example, you are promising that you will make a dead person alive. That is not physically possible. It should not be legally impossible. Legally impossible means if something is not allowed by law, if something is forbidden by law, and you are promising to give that, that is legally impossible. Number 3, it should not be uncertain. For example, if you are saying I'll give you a very good quality wood, what do you mean by good quality wood? It is uncertain. And number 4, it should not be illusory. Illusory means you are not promising to do something which you are already obliged to do under public duty or under an existing contract. Let us see both these points with examples. Case laws. So number 1 is Collins versus Godfrey. In this example, C received a summon, Collins received a summon to appear as a witness on behalf of G. So if you are receiving a summon by the court, you are obliged to do that as per the court, right? G promised that he will pay extra money to him for the trouble caused to him. Later G defaulted, he did not pay, and C sued him for the promise he made. It was held that C was under public duty already. C was supposed to go as a witness under the law. So if he was being promised some amount for doing that duty which he is supposed to do under the law, that consideration is not real and it is not worthy under the eyes of law. Right? Second case is case of Ramachandra Chintaman versus Kalu Raju. In this, Ramachandra was a lawyer, right? And he was under a contract with his client Kalu Raju. Now, Kalu Raju promised him that if he succeeded, he will give him additional amount. Right? So, what is the case? R is the lawyer and he has a contract already with Kalu Raju for fighting the case. Then Kalu Raju says that I will pay you extra if you win the case. Right? So this promise is void for the want of consideration, क्योंकि आप already एक contract कर चुके हो जिसके लिए आप services ले रहे हो. So you are supposed to give your best. Now promising another extra amount for winning is void because you are not getting anything in return. The second party is not getting anything in return. So lawyer here is under pre-existing agreement for the original contract. To do your duty properly, if you are offered another extra amount, then you cannot charge for that, then you cannot sue for that extra amount, right? So this is about that consideration should be real. Last thing is consideration may not be adequate. So there should be consideration. The presence is important, its adequacy is not important. कंसिड्रेशन का होना ज़रूरी है. कितनी कंसिड्रेशन है वो दोनों पार्टीज़ की बीच की अंडरस्टैंडिंग है, वो इम्पॉर्टेंट नहीं है, राइट? सो देयर इज़ पेपरकॉर्न थ्योरी. इसको हम पेपरकॉर्न थ्योरी ऑफ कंसिड्रेशन भी बोलते हैं, जिसमें हम बोलते हैं पेपर की तरह बहुत छोटा सा कंसिड्रेशन भी वैलिड है अंडर लॉ और वो लीगल ऑब्लिगेशन क्रिएट करता है, राइट? हाउएवर डॉक्ट्रिन ऑफ फेयर एक्सचेंज स्टेट्स कि अगर आपका कंसिडरेशन शॉकिंगली इनएडिक्वेट है और दोनों पार्टी में से एक पार्टी बोलती है कि उनका कॉन्सेंट फ्री नहीं था, तो वो जो इनएडिक्वेट कंसिडरेशन है दैट कैन बी डीम्ड एज एविडेंस फॉर not having the free consent, right? So if A is selling his bike to B, right, जिसका मार्केट प्राइस है, जिसका मार्केट वैल्यू आपको मिल रहा है 10,000 और आप खाली 1,000 का दे रहे हैं, तो ये वैलिड है, ठीक है, अगर आप दोनों की मर्जी से हो रहा है. लेकिन अगर ए बोलता है कि मेरा कॉन्सेंट फ्री नहीं था, राइट, सो दिस लेसर विच इज़ अमाउंट विच इज़ significantly less than the market price, so is basis पे A can win the case that his consent was not free, otherwise why will I give a 10,000 worth bike for 1,000? So this is doctrine of fair exchange. However, कितना consideration होना चाहिए that depends on both the parties A and B. consideration होना ज़रूरी है, कितना amount ज़रूरी है वो law prescribe नहीं करता. So these are the essentials of a valid consideration. अगर इसमें से कुछ भी missing है तो आपका consideration valid नहीं माना जाएगा and hence your contract will not be valid under the Indian Contract Act.